All right, excellent. We have a quorum. As everyone can tell, we have very tightly packed schedule today. So after the initial introduction of the bill by the bill sponsor, we will be limiting testimony to 2 minutes for each individual, so that we can attempt to get as many people to testify as possible, because I know a lot of folks are here and want to have opportunity to say something. So without further ado, Senator Berger, we begin with public hearing on your bill, which is, yes, number 9, Senate Bill 916. Please proceed when ready.
Chairman, members of the committee, thank you for the opportunity to present Senate Bill 916. For the record, Senator Jamie Berger, representing the 27th District, which is Scott, Cape, Perry, Ballinger, Madison, Iron, and Reynolds counties. This legislation addresses Missouri sovereign immunity statutes, specifically sections 537.600 and 537.610, which govern when the state and its political subdivisions may be held liable for negligence. These statutes have been the foundation of Missouri law for decades. They strike a careful balance between two important principles: protecting taxpayers from unlimited liability and providing a fair, predictable remedy for individuals harmed by government negligence. This bill preserves that balance. Senate Bill 916 clarifies and reinforces the legal protections afforded to those carrying out our critical transportation projects on behalf of the state. Specifically, it provides that private contractors and subcontractors acting within the scope of a government contract with the Missouri Department of Transportation are entitled to the same sovereign or governmental tort immunity as a public entity. This immunity brings on the department's official notice to proceed and extends through the department's formal acceptance of the completed project, ensuring consistency, fairness, and certainty for all property involved. Senate Bill 916 also includes the definition of the word purchase, the definition being only the direct acquisition of insurance coverage by a governing body and not any indirect action by contractor or otherwise. At its core, this bill is about clarity, stability, and fairness. It protects public resources while ensuring clear rules for legitimate claims. You know, I presented a lot of bills in the House and the Senate, but I don't know that I've ever had this amount of people show up in support of something that is so critical for our needs. And when we talk about highway infrastructures, every dollar that we have to spend in litigation or not protecting our contractors that are serving us so well with approval of MoDOT is one less dollar we could put on our roads and bridges to make our roads safer for all of us that travel these on a regular basis. With that, I'm open to any questions, but if we want to move on with time for the people testifying, that would be fine too. Some answers may be answered that way too.
Questions for the bill sponsor from the committee? Hearing none. Thank you, Senator. First witness in support. And witnesses, please make sure you fill out your witness card and leave that there at the desk. And your 2 minutes will begin, and please proceed when ready.
Good morning, Chairman Trent, members of the committee. My name is Dale Williams. I represent the Missouri asphalt contractors in the state of Missouri, approximately 1,000 folks that work on our roads day in and day out. And we've heard the purpose here, but really what is driving us is, we work for an agency that they give us the plans, the specifications that are all nationally recognized. We build them to those standards, and then we turn around and a lot of times we get sued because we have the insurance. We have the deep pockets. So that's really why we're here to support this bill. We can't change the plans. We do exactly what we're told to do. And, contractors get, like I said, we get sued because of the deep pockets, and we're following the plans, but we've had contractors get sued where they get a contract executed on a project. They haven't even shown up on the job. The contract, this example, was set up to fix an edge differential. There's an accident before the job even starts. The contractor gets sued, spent 12 years defending it. This is some of the things we're looking for. We're not asking for a get-out-of-jail-free card. If we're negligent, we're negligent. But if we're doing what we're told to do, we're asking for protection. And I would like to just key on a little bit of what the senator here said. This really costs the taxpayers. We estimate $1 million annually above what states that have tort reform in place. It costs our contractors to build a project. That cost gets passed on to the taxpayers. And if you look at that and we start thinking about safety improvements, that's 30 miles of shoulder we could build annually. 4.5 miles of guardrail we could put up. And I've got a colleague in the room, his father died in an accident where there was no guardrail. You know, had that guardrail been in place, that man would probably still be alive today. We could do another 11 miles of rumble strips. There's a lot of safety improvements we could do if we had this funding. So with that, I just ask this committee to support the bill, and I'd be glad to take any questions.
Questions for this witness? Yes, Senator, please proceed.
I have a quick question. One of the things that when we've seen that there's problems early on in litigation that could be solved, so for example, the one that you brought up, why not just allow that level of inquiry to happen earlier in the process so that dismissal could be done rather than changing how it's being adjudicated entirely?
I guess I'm not exactly sure I understand your question.
So for example, the federal rules about witnesses, we're looking at one of the bills that we've heard this year is about moving that forward, right? And so that we can make sure that the witnesses are going to be qualified as expert witnesses according to those rules in that hearing. We're moving up in the process, so we're not wasting all this time and then finding out that they weren't going to be qualified as an expert witness. Why not do the same thing about, you know, if the contract hadn't started yet, we can have finding of fact on those types of things earlier in the process and it can just be dismissed rather than saying, you know, we're giving blanket immunity.
Well, part of the problem is once the contract is executed, the contractor becomes responsible for the maintenance of the contract. Therefore, they're legally responsible for anything that happens on the project. And
Okay, so it's not, that's just my misunderstanding of the type of the way those contracts works. It's that they're done, once you are awarded a contract, you are now responsible for that section of road. It's not saying there's no, you know, initial action that has to be taken in order for that liability to start.
once it's executed, basically, the way our legal system works in the state, they're liable for anything that happens on that roadway.
Okay, thanks so much.
Yes.
Further questions for this witness? Yes, proceed, Senator.
I just have a question in regards to acting within the scope of the government contract. Here on page 2, where it says when acting within the scope of the contract with Missouri Department of Transportation. So how are we making sure that there's protections for negligence within that contract, if there is any negligence?
Yeah. I mean, basically what we're asking for is if we follow the plans and do everything that they tell us to do, that we get the same protection that the DOT enjoys. If they are negligent, then we're not asking for protection for that. But if we build it exactly like we're told to build it.
So it has to do with, again, maybe it's a contract question, how that contract is built.
Yep.
So you're saying if you're working within the confines of that contract, there's nothing, though, that would procure a lawsuit if there was a contractor who acted outside of the scope of that contract and was negligent, or willful misconduct or negligence, correct?
Correct.
Okay, thanks.
Further questions for this witness? Hearing none. Thank you for being here today. I have also been informed that there are still witnesses who would seek to testify that are out in the hallway. So if a witness has concluded their testimony and no longer needs to occupy a seat and would make space for another witness, that would be greatly appreciated. Next witness in support, please proceed when ready.
Thank you, Mr. Chairman and members of the committee. My name is Kristen Walker. I'm an insurance agent and owner of Walker Professional Insurance. Been in the business for over 20 years, and I work with over 250 architects and engineers across the country. We have been monitoring the increased claims frequency and severity in which our engineering firms are being named in these third-party traffic accident lawsuits in and around construction zones. As a result, insurance underwriters are imposing significantly higher deductibles, offering reduced liability limits, raising premiums, or considering firms ineligible if they do too much road work. States such as Alabama, Texas, and Florida, who extend these civil immunities to private companies acting within the scope of its contract with its state agency, are not experiencing these same ramifications. In fact, these states are seeing a reduction in firms being named in these lawsuits in the first place. Travelers Insurance Company conducts an annual survey of the top 100 verdicts across the country. Nuclear verdicts with awards over $10 million have increased in frequency 20% annually over the last 4 years. And for the first time, there were more mega nuclear verdicts with judgments over $100 million outpaced nuclear verdicts. We are trending in the wrong directions. Our firms cannot buy enough of insurance to protect themselves from these types of lawsuits. Now, you may hear concerns that private firms are trying to unfairly avoid liability. However, other states with civil immunity protections have cases that have upheld that if a private firm steps outside of its scope, the protections no longer exist. We need to preserve the insurance policy limits for actual acts of negligence, rather eating up insurance limits with these casted net lawsuits that cost firms on average $50,000 in expenses to then get let out on summary judgment because they're not supposed to be there in the first place. Or worse, suffering a seven-figure settlement when no negligence has been committed, but only for the fear of a desensitized jury imposing a nuclear verdict. I was born in St. Louis and raised in St. Louis, but I currently reside in Indiana, and I serve on ACEC Indiana's board, and we are doing similar efforts in Indiana so that we can sustain a partnership with our state agency. Happy to answer any questions.
Questions for this witness? Yes, Senator.
What's a nuclear verdict?
A nuclear verdict is defined as a judgment over $10 million. A mega nuclear verdict is over $100 million.
Thanks.
Further questions for this witness? Hearing none. Thank you.
Thank you.
Further witnesses in support?
Good morning. Thank you, Chair. Committee. My name is Joe Gildenhouse. I sit on the Missouri Association of Counties Board and the Commissioners Board of Missouri. Just want to support this bill. I think the bill speaks for itself.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you. Further witnesses in support?
Good morning, Chairman, members of the committee, and Senator Berger. Thank you for this opportunity. My name is Steve Bovanovich. I'm with HR Quadri Contractors down in Van Buren. I'm here on behalf of the Associated General Contractors of Missouri. We represent about 550 member companies all across the state, and we are here in absolute support of this bill. The bill addresses a serious problem for us contractors working on MoDOT projects. As has been stated earlier, we are under contract to build a project according to the plan specifications, contract drawings, engineered plans. That's what we do. But as doing that, we are routinely named in lawsuits over conditions we didn't create, we do not control, and had no ability to change. Too often, we are simply, as somebody said earlier, the first deep pockets. We're sued while work is underway, before work even begins, and actually after we're done. I can tell you firsthand that I have a story. I won't bore you with it. It actually caused a fatality on the project. Ironically, although the project was mine, the accident happened in an active work zone that the MoDOT department was doing within my confines, yet we were the ones that were sued. That is far from unique, but we've also seen other cases, such as somebody trips off of a sidewalk that was built in accordance with the plans and specs to the ADA standards. Again, we're the ones that are sued for that. All of this is to say that when you talk to contractors across the state, you'll hear countless similar stories. Many of my peers have the same type of stories. Circumstances vary. Some are nuisance claims, while other are major ordeals. But the result is almost the same. Years of litigation, considerable legal expenses, and rising insurance costs. All those costs do not disappear. Thank you.
Please conclude your thought, and then.
We're here in support of it. I'll take any questions.
All right, thank you for that testimony. Perfect, perfect, right on the dot. And questions for this witness from the committee? Hearing none. Thank you again for being here. Next witness in support.
Chairman, committee members, my name is Pat Kelly. I'm the Executive Director of the Municipal League of Metro St. Louis. Just want to go on record as support of Senate Bill 916. I want to specifically address the issue of the definition of purchase and why that's important. In 2021, there's a court case, it was Davis versus Buchanan, where the judge ruled that if a city is named, or political subdivision in the state of Missouri, all political subdivision, is named as a second insured, they waive their sovereign immunity. So currently, a very common and actually the standard business practice of being named as a second insured is waiving the political subdivision's sovereign immunity. So this just clarifies the issue was the definition of purchase in the statute. So this clarifies that and would make sure that that doesn't carry forward. I also want to thank Senator Trent. He's filed a standalone bill on this issue twice for us that we've tried to get across the finish line. Hopefully we can do that this year.
Thank you for that testimony. Questions for this witness from the committee? Hearing none. Thank you again for being here. Next witness testify in support.
Good morning, Mr. Chairman and members of the committee. My name is Rich Albish. I'm a registered lobbyist for the American Council of Engineering Companies of Missouri, the American Property Casualty Insurance Association, and the Missouri Civil Justice Reform Coalition, Inc., here and testifying in support of 916. I want to talk real quickly about sovereign immunity so that we all understand what we're doing here. This is a holdover from English law, wherein the sovereign, which is the state of Missouri, or the king, was free from lawsuit. That relates to absolute liability freedoms. There's also qualified immunity as well. So one is a freedom from liability and one is a freedom from suit entirely. Local governments also, like cities, counties, towns, villages, political subdivisions, they have governmental immunity by virtue of the state of Missouri. Some states' laws focus on discretionary versus governmental liabilities to determine what is a waiver for their liability. Missouri is somewhat unique. So we have a very specific statute that is in the bill that waives our liability for the sovereign to particular instances of claims. If you were to look at it, it would be in relation to vehicles, dangerous conditions of buildings, and contract claims. That waiver is found in 537-600. So in essence, what you're doing with this particular piece of legislation is creating a derivative sovereign immunity. Derivative sovereign immunity is not new. So Missouri, based upon 8th Circuit Court of Appeals and also a U.S. decision dealing with Yearsley versus W.A. Ross Construction Company, Yearsley versus W.A. Ross Construction Company, created a governmental immunity for the feds. It was based upon the federal constitution. A federal contractor doing work in Nebraska damaged an individual's piece of property. The claim was proper against the government, not against the contractor. This isn't new. This is just a different concept for Missouri using derivative sovereign immunity.
Your time has expired. Please conclude your comment. And
what I'm trying to say here for 916 is that while every other state's unique in their sovereign immunity dealings, Missouri is trying to do what here is create a derivative sovereign immunity. It's not a new concept. It's been going on since the 1940s.
thank you for that testimony. Questions for this witness from the committee? Hearing none.
Thank you.
Thank you again for being here. Next witness testify in support.
Good afternoon, Mr. Chair, members of the committee. My name is Jared Hankinson, Vice President of Government Affairs for the Missouri Chamber of Commerce and Industry. Nothing to add from the folks that have contributed. We'll just reiterate this is good governance, and the Missouri Chamber is happy to go on record in support. Thank you very much.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again. Next witness in support.
Good morning, Matthew Smith with Associated Industries of Missouri, going on record in support of this bill. We do support this bill because of the importance for our transportation projects. Expanded the scope of sovereign immunity for these contractors helps move along projects, and we're happy to support the bill.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Thank you, Chairman and committee, for just hearing this out. My name is Daryl Weniger, and I represent Capital Paving and Construction, based here in Missouri, and fortunate to be one of the largest partners to the state DOT over the years as a paving contractor in this arena. So if I can offer any additional perspective, it's that of the contractor. We're the ones that have team. I have 1,000 people that I rely on every day to make sure when we look at an opportunity to do a project in the state or with the state, we're prepared for the complexities of safety, mobilization, performance, quality, meeting all those specs. But one of the things that we continue to wrestle with when we do these risk registers and we look at the costs of doing business is the continued just risk that's out there as contractors beyond the owner of the project and things like that. So we're in very much support of Senator Berger and bringing this bill to you guys to make sure that I can work as hard for those 1,000 people representing 1,000 families that do tremendous execution, tremendous hard work. I wish everybody had a chance to stand along a lane drop in an interstate one time, because I think your perspective would change as fast as anybody that has had the blessing to stand in that environment, and the expectation, the professionalism, and the genuine care that they bring to each other and to the safety of it and the things that we can control. This represents one of the most unfortunate things that we cannot control, and a cost of doing business that affects our ability to be successful and to continue to grow and expand and do more in additional projects. So the contracting community is blessed and fortunate to partner with the state and the size and scale of the projects that we work on. We have tremendous craftsmen and women and men that work in these environments that are dangerous and complicated in general, let alone the things we can't control, which are these liabilities that don't match and just don't fit the additional responsibilities that we have or obligations that we have beyond executing and building the actual project itself. So I hope that maybe from a contractor's perspective, you guys could understand that it's a big deal for us.
Thank you for that testimony. Questions from the committee. Senator, please proceed.
How would this change affect you on a day-to-day basis in terms of operating?
This morning, I'm sitting in a room preparing for a design build project that we're pursuing in the state of Missouri. Our risk register was on the table, and there are things that we can measure and things that we cannot, and we have to keep putting that on the side, and the number is expansive. So at the end of a true complex estimate, 20% at times, 5 to 20%, depending the scope of the project, needs to almost be added to that estimate in these environments just to create with the potential risks that we face and the volume of traffic that we're working around and the litigious nature of the communities or the world in general. So 5 to 20% real cost, as recent as this morning before I was able to come here in discussion. It's every day in an estimate.
So in theory, if we wanted to as a state, we could hire up MoDOT, get our own paving machines, our own plants, and everything else, and use our own workers. And so in a way, it could be said the state's shirking responsibility and claims and money onto the contractors.
We clearly carry more risk when it comes down to the potential costs associated with performing work in this space. We do, yes. It is. I agree with that statement.
And even if this passed, there's no way, shape, or form that you're going to go out there and try and put out a subpar product.
Oh, no, my word, that's not what drives this business at all. Not at all. We're going to meet the specifications as required. Our target is just to overperform as any contractor. We're very proud of what we do, and the people that do this work are very proud of what they do. So compromising on specifications it's not an option. It's only excelling and mitigating risks associated with it.
And obviously, if you lower your safety standard, that puts your workers in harm's way also.
Absolutely.
And so that in no way, shape, or form would happen.
Absolutely. We can hire more safety people and more traffic mobilization and more engineering technical support with those dollars to provide an even enriched project when we don't have to allocate in a low bid environment many times the risk we have of not getting the job because of it. Absolutely. Well said. Thank you for that.
Thank you.
Further questions for this witness from the committee? Hearing none. Thank you again for being here and for that testimony. Further witnesses testify in support.
Good morning, Mr. Chairman. Hampton Williams with the Missouri Insurance Coalition. I want to thank Senator Berger for bringing this bill again. Happy to support it last year as well. We've heard some testimony from contractors who work in this field. Last gentleman just mentioned that, there's a premium of 5 to 20% on his projects that he's building out to address the cost concerns with this specific liability. With respect to MoDOT, that's tax dollars. That's what's being spent on these. And so, one thing I'd like to have folks be mindful of is we're addressing a specific sector, working for the government projects. Tort reform and these type of costs affect every single business in this state. So happy to support the senator on this bill. Would request your consideration for other opportunities to help support businesses with respect to tort reform on other bills. Thank you.
Thank you. Questions for this witness? Yes,
Hampton,
Senator.
I have a question that came up during the previous, but he's a contractor and you're a lawyer, so I saved my question for you, hoping that you'd be able to give me an answer. So Senator Gregory was asking about the standard of care and would that change? And I just wanted to ask your legal opinion about whether we would be preserving a cause of action when the standard of care were not met. So is it a blanket immunity that we'd be granting with this new type of immunity that we're creating here in Missouri, or is it the kind of thing that people do mess up? There are mistakes. The world isn't perfect. It's not a utopia. And so when at some point we have some contractor who may not actually perform, would we be making sure that those people who travel on our roadways would be able to be made whole?
Yeah, Senator, thank you for the question. The way the legislation is worded is that it's an extension of the statutory sovereign immunity, and the way that has been applied in case law is that there are still exceptions to that as a defense, negligence being one of those. And so, again, if this is an issue with respect to either defective construction or anything that's falling short of these standards, there's going to be a cause of action.
So not just
available.
Negligence, but every cause of action that is above that as well.
Well, and so, how this bill has been presented is accurate to say that the contracts that are used to establish the relationship and to identify these specs, that if these contractors do everything the government has asked them to do in the way they've asked them to do it, then they should not be exposed to any more liability than the government would have if it did it. And Senator Gregory's question, I think, was accurate with respect to a advantage that the state has in hiring these projects out, is that you're not having to carry the expense for the equipment or the employees or anything else, but you are shifting the burden on the liability in the event that there is an issue. And so,
is my understanding that currently that's true even if the contractor performs to the letter of the bid? So let's say MoDOT says you have to do these things. They appropriately do those things, but the design that they were told to do by MoDOT was wrong, that they would bear the liability for that rather than MoDOT?
well, and that's some of the testimony that we've heard today is that some of the contractors who have either built, things to ADA compliance or other requirements are still being exposed to lawsuits. And ultimately, while there may be some ability to address that on a motion to dismiss down the road, what this would do is allow an immediate defense for them to raise on a motion to dismiss early on in the proceeding.
Thank you so much.
Further questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Thank you, Mr. Chairman. Kevin McMullen, the Site Improvement Association. We represent around 300 contractors and support members to build the infrastructure throughout the state of Missouri, the roads, the bridges, all the utilities that go within. At this point, we are very much in support of the bill, and we appreciate the Senator for bringing it forth. This would protect our contractors from frivolous lawsuits, both at the front end of projects before they've even begun and during projects. In fact, even after projects have finished. With that, I just wanted to go on record. Thank you so much.
Questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support. They are not coming to testify. They're actually leaving. Further witnesses testify in support. Yes, Mr. Dorman, would you mind to call the hallway on Senate Bill 916? Would you mind calling the hallway on Senate Bill 916? Witness may proceed when ready.
Senator, thank you for the opportunity today. My name is Matt Morrow. I'm President and CEO of the Springfield Area Chamber of Commerce, and I don't have substantive items to add to what's been said today, just to agree with those comments that are made. In the interest of time, I will say that our 1,500, on behalf of our 1,550 member companies and the more than 100,000 taxpayers that they employ, we strongly support this legislation for all of the reasons that have been shared today.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses in support? Seeing none, witnesses here testify in opposition. Please come forward. You may proceed when ready.
How you doing?
Thank you, Chairman, Senators. My name is Wes Shoemate. I'm from Kansas City. I'm a lawyer. I'm on the Board of Directors, Executive Committee for the Missouri Association of Trial Attorneys. I'm here in opposition. I'm here not to speak for the folks that work for the companies or their insurers. I'm here to speak for everybody else. Those people are going to have their rights, their Seventh Amendment constitutional rights, trampled on, and I'm going to tell you exactly how. I may not be able to do it in 2 minutes because I talk a little slow, but I'm going to try to.
Well, and you can always submit written testimony to the committee, and we'll have that distributed.
I appreciate that.
Please
I
proceed.
appreciate that, Chairman. In these cases, we understand why we have sovereign immunity. That is to protect our government funds, our taxpayer funds. That's why it's there. That's why these limits of approximately $530,000 this year per person are in place. Those limits are about $3.5 million per accident. That means if 25 people are hurt or killed in one of these accidents where MHC is at fault, they all have to split that $3.5 million. To extend that further to these non-governmental, non-sovereign entities would quell the ability of people who are injured, the people throughout Missouri, my future clients, our neighbors, from being able to have access to the courts, because you can't just file one of these lawsuits and make it work. What you have to do is you have to hire your own engineers. There has to be accident reconstruction engineers, biomechanical engineers, traffic safety and control engineers. You have to have traffic studies done in most of these cases. When we're talking about these construction site accidents. That in itself costs tens, if not hundreds of thousands of dollars just to fund the case to start it. You also have clients. I have clients right now who are injured in a case on one of the major construction projects on one of our interstates. There is no doubt that there was contractor liability in this case. The dad was paralyzed for 6 hours before he passed away in the hospital. The mom was severely injured, suffered a series of strokes triggered by this, and will forever have 24-hour attendant care. There is nothing in here to assess for those future damages. Even when there were med-mal caps put in place, those were non-economic damage caps. Here, this is a straight across the board cap at this $550,000 or whatever it is this year. That doesn't help with the future care these people are going to need when they're hurt. And when you look at that, who's going to take care of this mom later? It's going to be the state.
Please conclude your thoughts.
Yeah, I'll do that very quickly. My point is, who's going to take care of that? When they're at fault, when somebody's hurt, when they need attendant life care, how's that going to be paid for? There's going to be health insurance or Medicaid, Medicare liens to take back some of the medical bill money paid out. There's going to be expenses that go into the case, and there's going to be nothing left for future care. So that was the end of my thought, Chairman. Thank you.
Yes, thank you for being here for that
Yes.
testimony.
Yes, sir.
Questions for this witness from the committee? Hearing none. Thank you again.
Thank you.
Further witnesses to testify in opposition? Seeing none, are any witnesses here to testify for informational purposes only? Seeing none, I'll go back to any witnesses to testify, since we did have a little confusion about the hallway. Seeing no witnesses, Senator, do you have any concluding remarks?
No, I don't. Thank you for allowing me to present, and we'll see where it goes.
Thank you, Senator. That will conclude the public hearing on Senate Bill 916. We will next move to public hearing for Senate Bills 907 and 1154. We will do them in tandem. And Senator, we'll begin with you, and hopefully our colleague will arrive
Okay.
After your
Yeah.
testimony is concluded, and then we can take his testimony.
So just to be clear, Mr. Chair, you want me to go now? Right?
Yes,
And-
yes,
okay.
please proceed
All right.
when ready, yes.
All right, didn't want to jump ahead. Mr. Chair, members of the committee, for the record, Brad Hudson, Missouri's 33rd Senatorial District, consisting of the counties of Stone, Taney, Douglas, Ozark, Texas, Howell, and Shannon, otherwise known as God's country. I am here to present to you Senate Bill 907. This piece of legislation before you would create the Act Against Abusive Website Access Litigation. Recently, a lone attorney from the Kansas City area and a client of his who happens to be blind have been suing Missouri businesses and alleging website noncompliance with the Americans with Disabilities Act. Hundreds of businesses have been sent demand letters alleging violations with threats of lawsuits unless they are willing to pay settlements. Dozens of businesses, in fear of expensive court proceedings, have capitulated to this shakedown. People with disabilities must be assured equal opportunities to full access to public accommodation. They are empowered to enforce the right to equal access through litigation if necessary. However, these predatory lawsuits, while brought under the guise of disability access, are abusing the system for the primary purpose of obtaining an award of attorney's fees for the plaintiff instead of remedying the alleged access violation. This bill would allow businesses 30 days to fix the issue before a lawsuit could move forward. This 30-day provision was brought up in the House as being too short of a period, and it was shifted to 90 days. I have had a Senate substitute or a Senate committee sub-drafted that reflects the changes made in the House. I had a discussion with Senator Nicola earlier today about adding his bill onto a bill string with mine if he is open to that. This is my number one priority bill, and I think we can get it done this year. A recently passed Kansas law allows businesses to sue plaintiffs and their counsel over abusive litigation related to websites not complying with the Americans with Disabilities Act. This law helps recover defense fees and potentially punitive damages. It went into effect on July 1st, 2023, and is the basis for the bill before you today. What is currently happening with one plaintiff and one lawyer suing businesses across the state, many of whom you will hear from today in some form, is not an attempt to help a harmed plaintiff. It is an enrichment scheme designed to bully businesses into fear and submission. I'll end my comments shortly as I want plenty of time for my friend Senator Nicola here to speak, and also for those who are here to testify to be heard. But I want to point out that this should be one of the most common sense pieces of legislation we pass all session. We all want those with disabilities to have access to services, but the process of getting there must be fair to our small businesses as well. Thank you, Mr. Chair.
Thank you for that testimony. Senator, would you like to proceed with your testimony as well, and then we'll have questions.
Thank you, Mr. Chair, and thank you, committee, for hearing my bill SB1154. For the record, I'm Senator Joe Nicola, serving 11th District, which is the northeast corner of Jackson County. This issue, and hopefully I won't repeat much of what Senator Hudson had to say as well, and I appreciate that this is your priority bill as well. I had personal experience with this during the campaign. I had a visually impaired constituent reach out to me and said they had a hard time distinguishing the colors on my website. So I asked them, because I'm the one that created my website, and I asked them, what are the changes that I needed to make? She told me what those changes were. I made those changes, got back with her. She said it was fine now. I can see those. That was my first experience with ADA compliant websites. Never heard of it before. I've asked many people about it. They haven't heard about it. A lot of small businesses don't know that they need to have an ADA compliant website. I've had a constituent also reach out to me and inform me of this issue. Then KMBC Channel 9 has done a story in Kansas City about ADA compliant websites with the lawyer that has been suing. I think he's over 100 different businesses now. Come to find out, his website wasn't even ADA compliant, but that's another story. So this bill really gives people, like if they a small business, I used to own a small business, at least give them a warning. You need to have an ADA compliant website. Give them 90 days. The 90 days is to at least initiate, because sometimes these takes, depending on the size of your business, you can have somebody taking care of your website, and it takes time to get this accomplished, and how big and complicated your website is, it could take some time. So giving them 90 days, I think, is fair to at least initiate the process, get it ADA compliant without just getting a lawsuit all of a sudden or a heavy fine on that. So you should have or committee sub before you, and we changed this because it's more in line now with Representative Maisie Christensen, and that bill has already passed the House side. And her and I have had conversations over the interim, so we brought our bills together to match, and it looks like that bill's going to actually be on the floor over in the House this week. So with that, I'd be happy to answer any questions.
Questions for the bill sponsors from the committee? Hearing none, thank you for that testimony. Witnesses here to testify in support. Please come forward. You may proceed when ready. I'm having a little bit of trouble hearing your microphone. You might make sure it's on. And
Oh, sorry.
Yeah, perfect.
Tamara Tatesian. I'm the CEO of the Callaway Chamber of Commerce located in Fulton, Missouri, just right across the bridge here. I am here in support of the Senate Bill 907. The reason for our support from the Callaway Chamber of Commerce is we have had several of our small businesses in Callaway County that have been affected by these ADA website lawsuits. Entrepreneurs, these small business owners, a lot of times are one-man shows, sole proprietors, and they're just trying to keep the doors open every single day. And when they get hit with a lawsuit that's costing them $20,000 to $30,000 that they didn't even know there was even any compliance issues, they may have made that website at home at 10:30 at night. Sometimes they just need a heads up because they don't know what they don't know. So it's really important to us to see that this is some action is taken to at least give them an opportunity to be aware and to correct the issue.
Thank you for that testimony. Questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support.
The committee, my name is David Overfelt, and I am the president of the Missouri Retailers Association, and we support both Senate Bill 907 and Senate Bill 1154. The House bill is up on the floor right now.
Oh, very good timing. Questions for this witness from the committee? Hearing none. Thank you for being here. Further witnesses testify in support.
Hello, Mr. Chairman, Senators. Thank you for the opportunity again, and thank you, Senator, for your support of small business in our community and our state. My name is Matt Morrow. I'm President and CEO of the Springfield Area Chamber of Commerce. For the reasons that have been stated here already, and on behalf of our 1,550 members, 85% of which are small businesses, we're supportive of the bill. We've had small businesses hit with these same targeted practices, so thank you for your leadership on it.
Thank you for that testimony. Any questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support.
Good morning, Mr. Chair, members of the committee. Jared Hankinson, Vice President of Government Affairs with the Missouri Chamber of Commerce and Industry. We'll keep things very brief here. You've heard from two local chambers the impact that this has been to them. Those are not unique stories. This is a statewide issue, statewide impact. It has impacted small businesses. If you've heard people that are trying to do their best to stay afloat in small rural communities, it has impacted large employers that are driving economies forward in our urban cores, and we think that this is essential legislation to, one, protect all of the businesses that are doing work in the state of Missouri, but two, to disincentivize this predatory and abusive litigation. We want to thank the Senator for bringing this legislation forward and for his collaboration with the other side of the building to make sure that we put together a package that has the smoothest possible path through the process. With that, I'm happy to take any questions.
Questions for this witness? Seeing none. Thank you again for being here. Further witnesses testify in support.
Mr. Chairman, members of the committee, Lynn Schlosser. I'm a registered lobbyist for the Missouri Association of Sheltered Workshop Managers. Shelter workshops provide employment opportunities for over 5,600 Missouri adults with disabilities. We'd like to thank both senators and go on the record in support. I did want to mention to you that we obviously care about ADA compliance, but there are actual ADA compliant computer operating systems for people that are sight impaired that are available.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again. Next witness testify in support.
Good morning, Mr. Chairman, members of the committee. Trent Watson, registered lobbyist here on behalf of the St. Joseph Area Legislative Partnership. Just want to lend our support. Thank you.
Thank you.
Thank you for that testimony. Questions for this witness? Hearing none. Next witness in support.
Mr. Chair, members of the committee, Will Mars on behalf of the Branson Lakes Area Chamber of Commerce. Just want to go on record in support. This is an issue we've heard about from quite a few of our members, so we appreciate the senator sponsoring this.
Thank you for that testimony. Questions for this witness? Hearing none. Further witnesses testify in support.
Mr. Chairman, members of the committee, thank you. I'm Dan Shaw, Executive Director for Missouri Grocers Association and President of the Missouri Midwest Retail and Grocery Alliance. We just had a Buy Missouri company call us on Monday about this exact thing, so that's why we're here today. Anything we can do to keep good quality price of food down, we'll do it. Thank you very much. Any questions, I'll answer.
Thank you. Questions for this witness? Seeing none. Next witness testify in support.
Thank you so much. Mr. Chairman, Brad Jones with the NFIB. Needless to say, I have had members call on this issue. I think it's kind of interesting. I heard about this issue about 4 or 5 years ago, and I was like, I don't think we've had any of these suits in Missouri. Well, guess what? We have now. So if you are finished, I'm going to go next door and listen to this. You know, it's just me over here, and it's not the first time that I have two things happening at the same time on opposite sides of the building. So there it is.
It's indeed a hectic day.
I can't be two places at once. I've never figured that one out. So
well, if you do, let us know.
I will.
Questions for this witness from the
Thank you,
committee?
Mr. Chairman.
Seeing none. Thank you again for being here. Further witnesses in support.
Sir, it's too bad you couldn't have gotten out a little faster.
Good morning, Chairman Trent and members of the General Laws Committee. My name is Jessica Hill, and I'm the Chief Public Affairs Officer for the Missouri Coalition Against Domestic and Sexual Violence. On behalf of MOCADSV and its almost 100 member agencies who provide services to the state's victims of domestic and sexual violence, we thank you for the opportunity to provide brief testimony regarding Senate Bills 907 and 1154, sponsored by Senators Hudson and Nicola. In addition to businesses, as you've heard, nonprofit organizations in Missouri have also been directly impacted by abusive website access litigation, including some of our own member organizations. While website accessibility is a high priority for MOCADSV and our members, the essential protections offered in this legislation are timely and necessary. Thank you for your consideration of this important legislation.
Thank you for that testimony. Questions for this witness? Yes, Senator, please proceed.
Good morning.
Good morning.
Thank you for being here. So I'm glad you're representing a nonprofit perspective on this because, you know, it's one thing for a business, even a small business, to have 30 days to comply. Congressman Sam Graves has filed a bill that would allow for 180 days to bring the website up into compliance. I'm sort of thinking we might need to have a little bit of flexibility there because I've been on boards of nonprofits where we wouldn't have the resources to do something within 30 days. So I just wanted to throw that out there to see if there's any flexibility in making sure we're meeting the needs of all entities, nonprofit and businesses alike.
Right, I think we would appreciate that opportunity to have some time to address the issues if they come up. Websites is something that you could easily see a nonprofit organization relying on a volunteer for.
Right.
And so, yeah, I would definitely agree that I like the 90-day option that's been presented today. 180 days would also be something that we would appreciate.
Okay, well, we'll discuss that offline. Thank you so much.
Thank you very much.
Thank you. Further questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Matthew Smith, Associated Industries of Missouri, just going on record in support of both of these bills. It's very clear that these lawsuits are only in existence to target businesses, and I believe the senator called it a shakedown, and that's exactly what they are. So, happy to support these bills.
Any questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support.
Good morning again. Senator Hampton Williams with the Missouri Insurance Coalition testifying in support of this legislation.
Thank you for that testimony. Any questions for this witness? Hearing none. Thank you again. Further witnesses in support?
Mr. Chairman, Shannon Cooper today representing the Greater Kansas City Chamber of Commerce, and it always gives me great pause to be supporting something so popular, but this is an unusual issue that really got a lot of our smaller chamber members in the Kansas City region stirred up as they were victims of this. So happy to support the legislation, be happy to answer any questions.
I'm sure you're equally uncomfortable supporting something that such a conservative senator as Senator Hudson has proposed.
It's great to team up with him.
Well,
maybe we're both moving closer to the middle here.
Well, we appreciate that testimony. Any further questions or comments from the committee? Hearing none.
Thank you,
you again
Chairman.
for being here.
Thanks.
Further witnesses testify in support.
Good morning. Rich Aubuchon on behalf of the Missouri Civil Justice Reform Coalition. Certainly we can't change federal law with this bill, but what we are doing is putting some teeth in for professional registration and professional conduct for the attorney, and also allowing the Attorney General to have some role in this as well, and I think that's good for the state of Missouri.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support. Seeing none, witnesses here testify in opposition. Seeing none, any witnesses here testify for informational purposes only? Seeing none, Senator, do you have any concluding remarks?
Yeah, I'll be brief, Senator. I believe as Senator McCreary mentioned the 30-day situation. I don't think you were here for my opening remarks, Senator. I believe the House bill is 90 days, and I've drafted a sub that says that. I'm happy to discuss 180 days. I'm not trying to speak for Senator Nicola here, but if he agrees or disagrees, he can chime in.
Yeah, I also wanted to address that.
Yeah.
So the bill says they, in good faith, they would have to begin the process in
Okay.
90 days, not be complete.
Okay, good, yeah. I have been part of nonprofits where we depend on somebody working at night, to help a nonprofit with their website, so very good, thank
I
you.
pastor a church, I understand.
Oh, yes.
All right, very good. Thank you for that, Senators. That will conclude the public hearing on Senate Bill 907 and 1154. We will next proceed to public hearing for Senate Bill 1202. Senator, please proceed when ready.
Thank you again, Mr. Chair, members of the committee. For the record, once again, Brad Hudson, representing Missouri's 33rd Senate District, consisting of the counties of Stone, Taney, Douglas, Ozark, Texas, Howell, and Shannon, still God's country. Here to present Senate Bill 12012 to you today, right now. This would adjust the assessment definition for machinery and equipment used to provide broadband communication services. Currently, these are assessed at the tangible personal property rate of 33.3%. This bill would lower that assessment to 12% only for machinery and equipment used to provide broadband communication service, and that is placed in service on or after August 28, 2026, for a period starting January 1st, 2027, and ending on or before December 31st, 2033. Beginning on January 1st, 2034, all of the machinery and equipment that had been used would revert to being assessed at the 33.3% rate, and everything that had been used prior to the August 28, 2026 date would also continue to be assessed at 33.3%. So to break it down, any equipment or machinery used to provide broadband services before August 28, before August 28, 2026 would be 33.3%, and that would continue at that rate. Between January 1st of 27 and December 31st of 33, that would be 12%. On January 1st of 34 and beyond, that would revert, that new infrastructure would revert back to 33.3%. This bill is necessary because states around us assess at a lower rate, and we are being outpaced for broadband infrastructure. Iowa and Kansas exempt the equipment. Oklahoma is at 22.85%, and Arkansas is at 20%. Passing this legislation would immediately make Missouri one of the most competitive states in the Midwest for new broadband infrastructure, something desperately needed across our state. This bill is a win-win for counties as it incentivizes new construction that will provide increased investment in accessible property, and after a 7-year period, sunsets, so all the new construction will provide an increased accessible value in the future. This is a win for counties, a win for our state, and a win for our citizens. I have experts here to testify to the technical aspects of the legislation, but I'm now happy to take any questions the committee may have for me.
Questions for the bill sponsor? Hearing none. First witness to testify in support.
Mr. Chairman, members of the committee, my name is Jeremy Ketterer with AT&T. We're here today to support Senate Bill 1202, sponsored by Senator Hudson, which modifies the assessment of new broadband communications equipment placed in service on or after August 28th of 2026. Importantly, this bill applies only to new builds, and existing broadband personal property will continue to be assessed at the current rate of 33 1/3. Senate Bill 1202 creates a new subclass of tangible personal property for qualifying broadband equipment. Under the bill, the equipment would be assessed at 12% of true value for the tax years 2027 through 2033, providing a clear 7-year sunset. This legislation is critical in encouraging continued broadband investment across Missouri. Broadband networks require significant upfront capital and long payback periods, particularly in rural and high-cost areas. Even a modest reduction in property tax can make projects that were previously uneconomical suddenly viable. Lowering the assessment ratio also helps maximize private investment. Every dollar saved can be reinvested into fiber deployment, cell sites, and network upgrades, creating local jobs for contractors, engineers, and skilled workers. Last year, we announced, thanks to the new federal policies in the Big Beautiful Bill, AT&T expects to invest more rapidly in next-generation networks across the country, increasing our investment by additional 1 million fiber customer locations annually starting this year. So Senate Bill 1202 follows that same proven model. Sound public policy, including tax relief, translates directly into infrastructure investment. Senate Bill 1202 also helps close the digital divide by making deployment more feasible in high-cost, low-density areas. The bill helps ensure that communities will have historically lacked reliable broadband can finally gain access. This is a market-based approach that encourages private investment without renewing state spending or requiring state spending while accelerating deployment where it's most needed. For these reasons, we are proud to support Senator Hudson and respectfully urge the committee to advance the bill. And thank you for your time. I'd be happy to answer any questions.
Questions for this witness from the committee? Yes, Senator, please proceed.
Good morning.
Good morning.
So if you could just emphasize the fiscal impact on local political subdivisions, when it seems like there's a lot of misunderstanding of how this bill will affect communities, including, I think there's some inaccurate information in the fiscal note because people didn't understand the legislation. So can you just briefly talk about, like, okay, so there's already something being taxed at 33%.
Correct.
It's not like that, if it's already in existence and it's not new, that tax rate is not going to drop.
Correct.
Okay, so this bill is only about
new builds, correct?
Right.
So that basically right now, so if we look at an area and we are not there, it's currently zero, right? Because there's no build. So if we go there, or if we decide to go there, the new build would be at 12%, and after 7 years, it would go to 33 1/3.
Okay, cool. I just think that's important because there's information in the fiscal note that contradicts what
Correct.
you're saying. So,
Yes.
okay, very good, thank you.
The fiscal note's inaccurate? You're kidding.
Not our staff's part. It's the feedback coming from people that were asked for input, and I think they just didn't understand the legislation, so thanks.
Thank you very much.
Thank you for that clarification. Further questions for this witness? Hearing none. Thank you again for being here.
Thank you. Thank you.
Witnesses to testify in support, please proceed.
Thank you, Senator. Mr. Chairman, members of the committee, Scott Swain representing Verizon. Senator McCurry, great point. I think it's very valuable. We reached out early on in this process with the Missouri Municipal League. We reached out to the Assessors Association. We've had those conversations. I don't believe they're going to be testifying today for that very reason, that this puts a priority on us investing in those cities, and that's when the tax benefit would be that inspiration to do so. So we want to go on record in favor, and thank you all for addressing it.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Good morning, or good afternoon. Noel Torpy with MCTA, the Cable Association. We want to go on record in support. I would say, you know, our member companies do look around at legislation across the country, and when you pass something like this, you know, we may be at 15th in Missouri. We'll bump up, we'll get higher, more of a priority from our CEOs. So I, you know, encourage the committee to support this piece of legislation. Happy to answer any questions.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Good morning. Matthew Smith, Associate Industries of Missouri, going on record in support of this bill. Lowering the assessment rate for 7 years down to 12% for broadband communication services and for the machinery equipment of that makes sense to keep us competitive for private investment, and it provides relief for industry in Missouri. I'd be happy to answer any questions.
Questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support.
Bill Gamble, registered lobbyist, appearing on behalf of the Missouri Broadband Providers Association, formerly the Missouri Small Telephone Company Group. We're in low-density population, high-cost areas. We very much support the bill. I don't want to disagree with the sponsor, but Mr. Chairman, I think you and I both would agree that Dade County is really God's country.
You know, it's all God's country at the end of the day. Thank you for that. Any questions for this witness? Hearing none. Outstanding testimony. Further witnesses to testify in support.
Good afternoon, Mr. Chairman, members of the committee. I'm Mike Sutherland here on behalf of the Missouri Electric Cooperatives. We have 17 of our cooperatives that have broadband subsidiaries that provide broadband in rural, hard-to-serve areas as well, and we think that this bill will help in affording that deployment in those hard-to-serve areas. Be glad to answer any questions.
Thank you for that testimony. Questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in support.
Mr. Chairman, Shannon Cooper with T-Mobile today, and once again, glad to be part of something that's so popular, speaking in support of the legislation. Be happy to answer any questions.
Questions for this witness? Hearing none. Very popular today. Further witnesses testify in support.
Good morning, Mr. Chair, members of the committee. Jared Hankinson, Vice President of Government Affairs with the Missouri Chamber of Commerce and Industry. I want to thank the Senator for bringing this legislation forward. Beyond the incentive to develop our broadband capacity and network in the state of Missouri, this is also an economic development tool for the businesses that rely on a sustainable broadband network. Helps retain those businesses in the state of Missouri and attract new employers to the state. And happy to take any questions.
Questions for this witness from the committee? Hearing none.
Thank
you
you
again for being here. Further witnesses testify in support. Seeing none, are any witnesses here testify in opposition? Senate Bill 1202. Please come forward and proceed when ready.
Mr. Chairman, members of the committee, my name is Kenny Moore. I'm the Boone County Assessor. I'm also the Legislative Chair for the Missouri State Assessors Association. The Missouri Constitution requires that all the property must be assessed uniformly and equitably. This bill would allow that broadband communication service companies be assessed and taxed differently than other similar companies. In 137.010.4, currently poles, wires, and equipment for electric energy, audio signals, video signals, and similar purposes are all real property under definition. Most of the broadband companies in the state are privately held companies. Giving assessment and tax breaks would not necessarily guarantee any reduction in fees, but I guess it would help them expand their services. So, beginning in 2025, businesses immediately were allowed to deduct 100% of the cost of their eligible assets fiber cable conduit, and towers were excluded from this. Reason being that they are considered long-lived items. So they are, as that being a part of real property. This bill, if this bill passes, how long will it be before we see cable companies and we see electric co-ops and we see electric companies coming in and asking for the same consideration? This is a slippery slope. I'll be glad to answer any questions.
Questions for this witness from the committee?
What is a similar company, sir? You said that we would have a problem because it's not available to other similar companies. What is a similar company that wouldn't be receiving this?
Well, we have.
Can you think of an example?
Well, I'm looking at how we assess like cable companies, and they're
So
assessed.
the assessors would support it if we extended this to cable companies as well?
I'm sorry.
Would the assessors support this if we extended this to cable companies?
I'm opposed to cutting the assessment on this. Is what I'm opposed to.
Okay, thanks so much.
And I'm also opposed to the fact that defining something that's already defined in statute as real property and classifying it as personal property.
Okay, thank you.
Further questions for this witness from the committee? Hearing none. Thank you again for being here. Further witnesses testify in opposition. Seeing none, are there any witnesses here to testify for informational purposes only? Seeing none. Senator, do you have any concluding remarks?
Nothing to add, Senator. I just appreciate the time. Thank you.
Thank you, Senator. That will conclude the public hearing on Senate Bill 1202. Senator, we will next proceed to the public hearing for Senate Bill 1064. Senator, please proceed when ready. Well, we've really hammered down now.
For the record, I'm Senator Ben Brown in the 26th District, and I'd like to thank the committee for the opportunity to present Senate Bill 1064. This bill is aimed at protecting small businesses involved in the sale of tobacco products. As with other small businesses, owners take on risk and invest a great deal of time, energy, and financial resources to start and build a company. This bill would create a general state preemption on the restriction of these businesses by local governments. Many companies have to market their products across the state, and the bill would provide them a much-needed level of consistency and uniformity across the board. Most importantly, it would help small business owners that have seen their business's value diminish due to unfair ordinances that have the potential to make it nearly impossible to sell to a potential buyer. One example of this was in 2019, St. Louis County amended its tobacco licensing ordinance that placed new limitations restricting retailers in certain locations from obtaining a tobacco license. Though it grandfathered in existing tobacco licenses, the ordinance specifically stated that when an impacted retailer wanted to sell their convenience store, gas station, vape shop, etc., the right to a license would not transfer over, meaning the buyer would not be able to obtain a license of their own. So when I first learned about this issue, I couldn't help but reflect upon my own experience as a small business owner, a restaurant owner. I purchased a restaurant at 28 years old. I worked year after year in the early years, often putting in well over 80 hours a week to try to grow my business, the sales, and increase its value. And did this for about a little over 6 years prior to the pandemic, and do a whole lot of very late hours, and I guess you could say good old-fashioned elbow grease. I was able to grow sales by 10% or more, and eventually it more than doubled the initial value. So what's happening to these real retailers? It's really no different than if a local government came in and said that anyone I sold my restaurant to would not be able to obtain a liquor license. So 6-7 years of hard work growing a business would essentially be erased, and the value of my business, an asset that I worked tirelessly to grow for years, would be evaporated. A business is an asset, just like any piece of real estate or any other. When one purchases an asset, we're staying night in the hopes of one day selling it for a profit. It's not right for the government to come in and undercut them, destroying something that they have spent potentially decades building, something they may have been relying upon for retirement or to provide for their family. Small businesses are already dealing with a number of challenges, including record levels of inflation, labor shortages, and other unprecedented obstacles. Government should not be creating additional ones and actively working against small business owners. I'll also add that after discussing some concerns with senators last session, I did add a provision to clarify that this would not prohibit political subdivisions from enforcing ordinances or regulations that set the age to sell or purchase tobacco products at 21. And also, since St. Louis County has since backtracked on the licensing restrictions, I did add a provision as well that exempts any ordinances, orders, rules, or regulations that were enacted prior to January 1st, 2026. And with that, I would be happy to answer any questions.
Thank you for that presentation. Are there any questions from the committee for the bill sponsor? Hearing none. First witness here to testify in support, Senate Bill 1064.
Thank you, Mr. Chairman, members of the committee. My name is Jake Silverman, registered lobbyist for the Missouri Vape and Alternative Products Association. We just want to go on record in support of this bill and thank the senator for sponsoring this. Vape stores, there's over 1,500 of them in the state of Missouri. They sell products that are flavored, and that's about 99% of their business. And so what we've seen in other states, California, Colorado, and even the city of Kansas City attempted to do a flavor ban, and so that puts a lot of these stores at risk with their products that are inside of them. So we just want to, we think that this legislation is the perfect way to ensure security for these small business owners so they can sell the products that help put food on the table for their families. So with that, I'm happy to answer any questions.
Questions for this witness from the committee? Hearing none. Thank you again for that
Thank you.
testimony. Further witnesses testify in support.
Mr. Chairman, members of the committee, good morning. My name is Ron Leone. I'm the Executive Director for the Missouri Petroleum and Convenience Association, and what that means is my members are many of your constituents who either own, operate, or supply gas stations and convenience stores. I want to thank the sponsor for introducing the bill. We're here in full support of the bill, as well as the companion House bill, which is 2085. Part of my testimony was going to go into some detail regarding two examples that the sponsor covered very well, the Kansas City flavor ban that was proposed, as well as the licensing issue we had in St. Louis County. But since time is tight, and since he did such a good job, Mr. Chairman, I'm going to focus on a couple of reasons why we think local tobacco ordinances are bad for businesses and adult consumers, and why tobacco preemption, which is what this bill is essentially called, at the state level is needed. Local tobacco ordinances limit the choices of adult consumers. Local tobacco ordinances do not actually decrease demand or decrease consumption. They simply push the adult consumers to buy tobacco products in either border cities, border states, or on the internet. Local tobacco ordinances devastate brick and mortar local retailers, my members, your constituents. Not only do the retailers lose the tobacco sales, but they also see a massive reduction in accompanying sales, such as gasoline, food, and general merchandise. Local tobacco ordinances, which may push sales to our border states, especially Kansas City, if you have something in Kansas City or St. Louis, it'll deprive Missouri of critical excise tax revenue used to fund state programs. Mr. Chairman, you've heard this bill before, and so I will summarize by saying tobacco is not a local issue. Regulating or banning tobacco products is best left up to Jefferson City or Congress so that all Missouri retailers are playing by the same uniform, consistent, and predictable rules. Mr. Chairman, I appreciate the opportunity to be here today. I'm happy to answer any questions.
Thank you for that testimony. I just assume we not get Congress involved. It seems like there's ways that could go awry. Questions for this witness from the committee? Seeing none, thank you for being here. Further witnesses testify in support.
Good
Morning, Mr. Chairman, members of the committee. My name is Kenny Dobson. I serve as the Vice President of Ware Brands, a company that owns and operates 35 tobacco stores in Missouri and Illinois. Statewide preemption is critical to preventing a confusing and inconsistent patchwork of local tobacco regulations from taking root in Missouri. If cities and counties begin creating their own rules, we, as retailers, will face a maze of regulations that vary from one locality to the next. As a company with 10 stores across 9 different Missouri cities and 25 stores across more than 20 different Illinois cities as an example, this would create significant operational challenges, increase compliance costs, and raise the risk of unintentionally violating conflicting laws. When local jurisdictions impose stricter rules than the state, such as a product ban, customers simply travel to a neighboring area where those items remain available for sale. These customers don't just buy tobacco, they purchase other items too. That means businesses in more restrictive areas lose out on additional sales, creating an uneven playing field. Local restrictions also jeopardize Missouri's tax revenue. We operate 4 stores near the Illinois border. If any of those localities enacted a flavor tobacco ban, customers could easily cross into Illinois to buy their preferred products. Retailers would lose those sales, and the state would lose critical tax revenue, both sales and excise taxes, from these cross-border purchases. And I'm just going to get off script here for a moment to say, I love the state of Missouri. I live in the state of Illinois, and for some reason in the last year, local municipalities in Illinois, and we're in a lot of small towns, are just suddenly, I view tobacco as something that is seriously regulated at the federal level, well thought out at the state level. We have these debates, and then at the local level, you never know what's coming. When we talk about tobacco in the state of Missouri in regulation, we have debate, we have science, we're able to make much better decisions. Thank you.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Very quickly. Members of the committee, my name is David Overfelt, President of the Missouri Retailers Association, and of course we support this bill.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Mr. Chairman, members of the committee, I waited my turn this time. Dan Shaw, Missouri Grocers Association, and President of the Midwest Retail and Grocery Alliance. We're too in support of this for some consistency across the state.
Thank you for that very orderly testimony. Any questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support.
Matthew Smith, Associated Industries of Missouri. Just want to go on record in support of the bill.
Thank you for that testimony. Questions for this witness? Hearing none. Further witnesses testify in support.
Thank you, Chairman and members of the committee, and thank you, Senator, for sponsoring the bill. I'm General Counsel with Motormart. We have a significant presence in Missouri and Illinois. We're a Missouri corporation, and we support this bill for the reasons that have been stated before here, and I just echo those sentiments. Thank you.
Thank you for that testimony. Sir, could you please state your name for the record?
Kenneth Goins.
Thank you. Any questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses in support.
Mr. Chair, members of the committee, my name is Ron Berry. I'm here today on behalf of Warrenton Oil. We have about 60 convenience stores in 38 different municipalities, and this is a very highly regulated industry that would just provide some consistency.
Thank you for that testimony. Questions for this witness? Hearing none, thank you again. Further witnesses in support.
Good morning, Mr. Chair, members of the committee. I'm Angie Schulte. I'm here on behalf of Casey's General Stores to support the bill that the senators put together. We're also a member of Mr. Leone's association, and we're just here to go on record in support.
Thank you for that testimony. Questions for this witness? Hearing none. Also very timely. You got the last minute of the morning before we made the transition. Further witnesses testify in support.
Just verified on your laptop. Good afternoon, Mr. Chairman. Heath Clarkston here on behalf of Maverick Convenience Stores in full support.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Further witnesses testify in support. Seeing none, are the witnesses here to testify in opposition? Please come forward and proceed when ready.
Thank you, Committee. Emily Kalmer, American Cancer Society Cancer Action Network. We've previously testified against this legislation. I think I've worked for our organization now for about 7.5 years. There's been a bill to do this for the last 6 sessions, I believe. It's interesting to hear each time the reasons because they change from session to session. What we know from our history of advocating at the local, state, and federal level on cancer issues is that this has been a long-term industry strategy to preempt action at the local level. They know that local governments will listen to their constituents when they're seeing an issue and act. Some of the activities and some of the evidence-based strategies that have contributed to the decreased cancer rates in recent years have been actions like local smoke-free ordinances. And they have proven strategies that have worked for the reduction in cancer deaths in recent years. While the industry's products evolve, their strategy is staying the same. And just to be clear, when they say they have the science at the state level, tobacco is the #1 cause of preventable death in the United States. It contributes to 34.4% of cancer deaths in Missouri. So I don't think there's any dispute that the science shows that this product is deadly. There's nothing in this bill that provides further protection to young people. Quite the opposite, it ties the hands of those communities who want to respond to the issues. While the bill this year includes language grandfathering in existing ordinances, it specifically says that if the local law is amended after this past January, it will be nullified. So therefore, if a community updates its ordinances to address emerging issues or products, as we see them continue to evolve, they would be preempted. So for instance, recently, Fulton saw issues and passed an ordinance in December. If they wanted to make refinements to that, the way the language is written, it says if the ordinances are amended, they would be preempted. So for those reasons, we continue to oppose this legislation.
Thank you for that testimony. Questions for this witness from the committee? Yes, Senator, proceed.
So to think that over 34% of cancer deaths in Missouri are caused by smoking, so by tobacco, I guess. I assume that also has an impact on healthcare costs through Missouri Medicaid, and the fiscal note doesn't capture that. So do you have any sense of the fiscal impact on smoking and how it affects Missouri taxpayers?
Oh, yes, and I have those stats. It's billions of dollars and millions of dollars. I'm sorry, I didn't put that in my remarks today. I have a fact sheet that I can bring around to share with you. In fact, one of my compatriots from another patient organization may have that in front of them right now. But it contributes to the healthcare costs that the state's facing every day.
Yeah, I think, because the state budget is such a mess right now, I'm trying to think, be thoughtful about things that we're doing that could actually help lower expenses for the state and help the taxpayer out. So I'd like to see some of that.
I was a little surprised to hear folks were concerned about people going to Illinois from Missouri. Missouri has the lowest tobacco tax in the country at 17 cents. So just that part of the previous testimony was also a little interesting to me in that they previously opposed tobacco tax increases, but now they're saying that folks will go to another state.
Well, I think the opposite would be true. If it's on the east side of the state, like where I live, people would just go further west in Missouri, where there maybe isn't as much focus on health.
So, thank you.
Yep, thanks.
Further questions for this witness? Hearing none. Thank you again for being here. Further witnesses testifying in opposition, please proceed.
Chair, members of the committee, Mara Patel on behalf of the American Heart Association testifying in opposition to Senate Bill 1064. Like Emily had mentioned, tobacco use is one of the leading causes of preventable death and is a major risk factor for cardiovascular disease. So it's no surprise that we are in opposition to this type of legislation. To the senator's question, in Missouri, healthcare cost by smoking is $3.52 billion. Medicaid cost by smoking is $692.6 million. And the yearly household tax burden is $1,158. And so one other point that I would just like to add at the end, our state was just awarded almost $216 million from the Rural Health Transformation Fund, and the purpose of that money is really to hone in on chronic disease and chronic disease management and really improve health outcomes at the end of the day. And so I would implore you not to pass legislation on the back end that would essentially undermine that investment. So with that, I will close and happy to take any questions.
Questions for this witness from the committee? Hearing none, thank you again for being here. For witnesses in opposition.
Mr. Chairman, Jacob Scott with the Missouri State Medical Association and the Missouri Association of Osteopathic Physicians and Surgeons, two largest trade organizations of physicians in the state. I want to go on record in opposition. I'm just here to tell you that smoking is bad for you. So,
thank you for that testimony. Questions for this witness? Seeing none, thank you again for being here. Further witnesses testify in opposition. Seeing none? No, seeing one.
Mr. Chair, members of the committee, Will Mars on behalf of the Missouri Public Health Association. Just want to go on record in opposition. Twofold is our opposition. I'd say we had a previous speaker mention the concerns about previously passed ordinances and what this new language would do. So some concerns over litigation there, but also generally speaking, previous ordinances passed by local public health agencies have contributed to a significant decrease in cancer rates. So just want to go on record in opposition.
Thank you for that testimony. Questions for this witness from the committee?
Thank you.
Seeing none. Additional witnesses testify in opposition. We seem to have had a late witness arrive for in favor, so please come forward quickly and proceed.
Thank you so much for the indulgence, Mr. Chairman. My name is Arnie C. A.C. Dinoff, State Public Advocate. I just want to go on record in support of SB 1064. I believe in a statewide, across the board. On the eastern part of the state, we have way too many political subdivisions, too many cities, towns, a lot of counties, and a lot of these jurisdictions are overlap. If you take St. Louis County, for example, I believe there's 89 municipalities. So this is a uniform, across the board, even keel playing field. So anybody that wants to purchase these products need to know the rules and regulations, the promulgated rules from the Department of Public Safety, Division of Alcohol and Tobacco. And so I would be in favor of a statewide rules and promulgated rules, please.
Thank you for that testimony. Questions for this witness? Hearing none. Thank you again for being here. Any further witnesses in opposition? Seeing none. Any witnesses here testify for informational purposes only? Seeing no additional witnesses of any variety, that will conclude the public hearing on Senate Bill 1064. Senator, did you have any closing remarks?
I'll just say, there's good points. I don't think anyone's here trying to argue that tobacco's good for you. We all know that it's been well documented the negative health impacts they can have. Along with things like alcohol. I mean, a substantial number of people die every year from alcohol consumption, and that's not even considering drunk driving and other factors. That's regulated at the state level. I mean, even marijuana is regulated at the state level. So it seems only fitting that tobacco would be regulated at the state level, have a consistent policy statewide as well.
Thank you, Senator. That will conclude public testimony for Senate Bill, or public hearing for Senate Bill 1064. We'll next proceed to public hearing for Senate Bill 980. Senator, please proceed when ready.
Thank you so much, Mr. Chairman, members of the committee. I promise I'll keep this as fast as I can. Mary Elizabeth Coleman, representing the 22nd Senatorial District. And this is a bill about how we deal with the state, with a state fund that was created. So we have the Tort Victims Compensation Fund. We have a crime bill fund. We have a myriad of different programs that are created across the state to try to help when someone is harmed and there isn't resources for that person to be made whole. And so crime victims, tort victims, all these different pots are trying to see how does the state step in and take care of our taxpayers when something has terrible that has happened to them. So between, really the purpose, I think, if you're going to classify it in one way, is to make sure that victims are not harmed twice. So there is two proposals that I am making to try to look at changes to the compensation fund. The first is to require that there's U.S. citizenship or a lawful immigration status in order to receive eligibility, and the second is to make sure that we have oversight of attorneys' fees. We have literally no time left in this hearing, and most of the committee has had to move on to other obligations that are double booked. So rather than go in detail into this bill, I'm happy to answer any specific questions that people have, and I'm happy to visit anyone in their office as well. But just in the interest of time, those are the two things that the bill does. This is the purpose of the fund, and trying to bring in line the purpose to make sure we are protecting taxpayer dollars and having the most resources available for those who are harmed, by putting some common sense restrictions that are in place in other areas of the law onto this fund as well.
Thank you, Senator, for that presentation. Any questions for the bill sponsor from the committee? Hearing none, thank you again. First witness in support, please proceed when ready.
Good afternoon, Mr. Chairman and members of the committee. Hampton Williams of the Missouri Insurance Coalition. I want to thank Senator Coleman for highlighting this issue. We're here to talk in support specifically of the attorney's fees section with respect to the Tort Victims Compensation Fund. There's kind of an oddity that there is an administrative rule with the Department of Labor which identifies that the Department of Labor is not permitted to review attorneys' fees with respect to applications for the Tort Victims Compensation Fund. Now, it does authorize them to cut two checks, one to the claimant and one to the attorney, but they're not actually allowed to determine the reasonableness of attorneys' fees with respect to those types of applications. When you look at how the state has treated other types of victims' compensation fund, the Crime Victim Compensation Fund, for example, there's a 15% cap. Now, there have been other types of funds which contingency fee contracts, 40% contingency fee contracts, have been determined unreasonable. That's Clark v. GM LLC. A federal court struck down a 40% contingency fee award on a fund application. So we know that there are circumstances where courts have determined that these are unreasonable because of the amount of work necessary to justify the funds. The second issue is that there's a professional rule of ethics, 4-1.5, which prohibits attorneys from making agreements or collecting unreasonable fees. The problem is with the Tort Victims Compensation Fund, because of this rule, there's actually no one at the switch. There's no person responsible for making a determination whether or not a fee is or is not unreasonable. And so if you, the other issue that kind of highlights that what a concern this is, in the past 3 years, there have been over $200 million paid out of the Tort Victims Compensation Fund. If there's a 40% contingency fee on top of that, that means that it's potential that there's $80 million that have been paid to attorneys and not to the victims that they're meant to compensate. So what's the purpose of the fund is? It's why we have a cap on the Crime Victims Compensation Fund. This bill would impose a similar cap on the Tort Victims Compensation Fund, which would actually, again, work to make sure that the money is going to the folks that need it. I have a list here that I'll submit with the committee that identifies 67 other statutes that where courts are given the discretion, or at least the fact finder, administrative officer, or anything else, to make a determination of a reasonable sort of attorney's fees, and we appreciate your time.
Thank you for that testimony. Questions for this witness from the committee? Hearing none. Thank you again. Further witnesses here testifying in support. Senate Bill 980.
Thank you, Mr. Chairman, members of the committee. My name is Arnie C. AC Dinoff, State Public Advocate. I'm in favor of SB 980. I believe I do have some issues with the citizenship, and I think that there needs to be some amendments if the sponsor would be willing to make those. You have to put your shoes in some specialty items. There are some foreign residents that have to travel to the United States to do some certain professions and certain industries that have certain insight to correct things or fix things or engineer things. And so I would hate for a foreign resident to come to our country, get hurt on the job, and then not be compensated accordingly to our second injury fund, number one. But overall, I believe that you have to be a U.S. citizen to be eligible. And the other thing is the oversight of attorney fees. It's about auditing. It's about responsibility and accountability. A lot of times attorneys want to slip in extra hours, extra expenses when they actually didn't provide the service or provide the consultation or the representation. And I think it's sad when we have attorneys that take an oath of office to uphold the Constitution and all promulgated rules and regulations of the Missouri Supreme Court, but yet backstab the system and try to get illegal hours or illegal expenses. We need to cut down on that. That's fraud. That's embezzlement, in my opinion, and I think those people need to be held accountable and at a higher bar. And if somebody has fraud out there, they need to report that to the Attorney Discipline Council through the Missouri Supreme Court. Thank you, Mr. Chairman.
Questions for this witness from the committee? Hearing none. Thank you for being here. Thanks. Additional witnesses testify in support. Seeing none, are any witnesses here to testify in opposition? Please come forward and proceed when ready. I think your microphone may be off.
Can you hear me now? Okay.
Yes.
Chairman, members of the committee, I'm here to testify against this bill. My name is Randy Alborhaski. I'm a personal injury and workers' compensation attorney in Springfield, Missouri. Two main points I'd like to make. First of all, I'm a believer in free markets, coming from being a businessman, a lawyer, and an economist by training. I think this bill inhibits the free markets by restraining the ability of people to contract between the client and the lawyer. And I think that's bad. That's not what we generally want to accomplish. But more importantly, I think the goal of this bill is to put more money in the pockets of the injured, but in fact it will have the opposite effect. Studies have proven time and again that when people have representation, they end up with 2 to 3 times more compensation in the end, even after attorney fees and expenses, than if they don't have an attorney. So that alone is going to reduce how much compensation people will get. And this is compensation that was funded through punitive damages that tort attorneys obtained. So it's not taxpayer money, it's what attorneys like me have gone out there and gotten for the state to give back to tort victims. And these are victims. Let's examine who they are. There's a crime victim fund, but many tort victims are also victims of crime. I know of a couple instances, colleagues of mine who have represented young boys who were sexually molested, raped by their father or stepfathers, and these are not simple cases. They were able to hire experts at some cost, psychiatrists, psychologists, economists, and pursue claims to put money in the pockets of these children who have been violated. And because of the recovery they got for them, they were able to obtain treatment, have a life care plan, have something to live on besides Social Security disability when they turned 18, because that's what they ended up doing. I myself can tell you that I represented a police officer who was drugged 25 feet by a criminal in a car, ended up being tossed off the side of the car and injured his shoulder. I've invested $6,000 to $7,000 in prosecuting his case. The effect of this bill will prevent attorneys from being able to represent clients that need representation. And that concerns me, because these are people that otherwise don't have a source of compensation. The Tort Victim Fund is for people who, there's no other insurance. There's no one who insures a criminal, for uninsured drivers, so forth. These are people that have a last resort, and, if they don't have an attorney, they're not going to file a claim, or if they file a claim, they're not going to do it well, and they're not going to be fully compensated. So I'd be glad to answer any questions you have.
Questions for this witness from the committee? Hearing none, thank you again for being here.
Thank you.
Further witnesses testify in opposition? Seeing none, any witnesses here testify for informational purposes only? Seeing none, Senator, do you have any concluding remarks?
No, I just wanted to conclude and say these funds are really important to victims of torts, and we are currently been operating under that rule for the attorney's fees rule for the Crime Victim Fund, and it has not meant that those people no longer have representation. We have a finite pot of taxpayer dollars, and we want to make sure that most of that money is going to these tort victims, not going to representation. And that money and that system is currently working in the Crime Victims Fund, and we have 67 state statutes that are allowing various funds to have judicial or finder of fact review over attorney's fees. And right now, we're specifically not allowed under a department rule in the state to even look at whether those fees are egregious. And I just think that's wrong. I'm a lawyer. I don't think that people are misbehaving always, but there are always bad actors, and we want to preserve the pot of money. I think that the idea that these funds should also be for Missouri citizens and those of legal status, it's not mean-spirited. It's not trying to say that we shouldn't have it because they don't get hurt as well, but it is about making sure that taxpayer dollars are making taxpayers whole. And we have nationally federal programs that require that those safety net programs also only go to those with legal status, including Medicaid, CHIP, SNAP, SSI, TANF, ACA, Section 8 housing. So I think that the language currently does have a carve out for anyone who is legally a resident or in the state of Missouri, whether you are a citizen or not, but we want to make sure that taxpayer dollars are going to taxpayers when they're harmed, and there's no other recourse to them. This would be about a $35 to $40 million addition to the fund that has about $150 million. That's more than we're putting into that via the general revenue. So this is about trying to preserve resources for those who need them the most. So anyways, thank you for the hearing. I appreciate it.
Thank you, Senator. That will conclude the public hearing on Senate Bill 980. With no further business coming before the committee, I make a motion that committee stand adjourned. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. The ayes, any opposed say no. The ayes appear to have it. The ayes do have it. The committee will stand adjourned.